Welcome to the Estates Made Simple podcast with Jenna Carvalho and Gordon VanderLeek. We are on a mission to simplify the world of estate administration, helping executors gain the knowledge required to manage an estate. Please note, the following is for informational purposes only and is not to be considered legal, tax, or financial advice. We recommend you seek individualized advice for your unique situation with qualified professionals.
Welcome to another episode of Estates Made Simple. I'm Jenna Carvalho and here with my co-host Gordon VanderLeek. Today we are going to focus on something that is important to a lot of families in Alberta and also the rest of Canada. We're lucky to have Gordon. He and his firm tend to be the expert in this area that we're going to be speaking about today. And I don't know if that was on purpose or by accident, just by more and more clients hearing about your firm, Gordon. But today we're going to talk about estate planning for beneficiaries with special needs. It affects a lot of us, and it's a very complex planning scenario that we need to ensure that we do proper planning for. So we're going to ask you lots of questions, Gordon, and I know you're going to know all the answers.
Delighted to jump into the topic. To what you said by way of introduction, that's been a bit of our personal story, having children with special needs in our own family. So we obviously are very interested in it to stay on top of this area. And I think over the years now, doing more and more work in the area, have attracted other families in a similar situation to come, and then that kind of builds over time, right? To the point that's the reputation you have or your perceived area of expertise. So yeah, we're always happy to talk about this topic, and it is important. It's a little bit, there's a level of complexity there, right? That is important from a planning perspective, and some complexity if you're dealing with an estate that involves a child that has a long-term disability, that has special needs, and there's right ways and wrong ways of handling those things and sensitivity. So I think a planning aspect to this topic that we can talk about, as well as highlighting some important points from an estate administration perspective.
Mm-hmm. And I think it's really great that you have experience personally in this space, because a lot of times advisors don't know how the family is feeling and all the struggles are going through. And so you've lived it, you've experienced it, and you've been successful at achieving the necessary supports for those you love. And so when you are working with clients, tell me, what are the first few things that they should consider when they're planning their estate for their beneficiaries with special needs?
Yeah, one of the first considerations would be an appropriate trust structure. It's interesting when you look at sort of the history of trust planning for families with children or other family members that have special needs. Alberta stood alone historically as a province that didn't really create an option or a viable option with regard to trust planning. And this is in relation to government support. So a lot of the planning relates to how do you make adequate provision for this child that can't support themselves or struggles with needs that are greater on their own, and they're not independent. The disability as such is that they can't support themselves. Their needs are greater than their income or their ability to support. So the parent then would have a legal obligation to provide for them. Certainly one of the aspects of that support would be what government supports. Very commonly in Alberta, we have a program that has the acronym AISH, Assured Income for the Severely Handicapped, AISH, and that provides a monthly stipend, if you think of it almost in lieu of an employment check, that if the person can't work, they have something to pay for the basic necessities of life, to provide rent, a place to stay, to buy groceries, to be able to get a bus pass for transportation, some of those basic things in place. The government support programs, a lot of times, not exclusively, but a lot of times have an asset test component that you can qualify for these programs as long as you don't own too much, which sort of makes sense if you think about it from a government perspective, looking at it from the perspective of the taxpayer. If somebody has plenty of money on their own, then why would they need the government support? And they can't support everybody. It's not a universal sort of income program. It's meant for people who have long-term disabilities. So the AISH program has an asset test that's specific to Alberta, but there's similar tests in other provinces and territories in Canada. And in Alberta, it's $100,000. So you can own up to $100,000 and still be eligible for the program. If you own more than that, you're not eligible for the program, even though you might have a significant disability that would otherwise qualify you if you're looking at it in terms of the severity of the disability. From a planning perspective, we run into a problem where a parent can't just give a bunch of money to a child with special needs because that's going to disqualify them from the government support programs. But also, I think the other thing to recognize from a planning perspective would be the vulnerability of that person. If they just received a bunch of money, would people take advantage of them? Would they be able to make appropriate decisions regarding protecting that money, managing the money? If you came into some money, you won the lottery, you got an inheritance, you would sit down with a financial advisor and say, okay, how do I plan for this for the long term? What kind of investment should I go in? What's my risk tolerance? All the sorts of things we think about in our own savings and our planning for our financial future. Somebody with a long-term disability may not be able to engage in those types of conversations. Or they might be such that, but they could be duped. They might make poor choices. They may be subject to influence that a friend or relative could steer them in the wrong direction. So now they're being taken advantage of. So that's a lot of the concern of the parents to say, how do I manage that? And a solution there is going to be setting up a trust. So it would be a trust that forms on death. So it's a testamentary trust. And it's available, typically the term would be for the lifetime of the disabled beneficiary. And if it's in that trust structure, the good news since 2018 in Alberta is that trust would now be exempt for AISH purposes. And so that would not kick the person off of that government support program just because a parent passed away and left them some money. So definitely you want to make sure that you don't, it's just not an outright gift. If you're looking at it because that's just going to create an immediate eligibility problem, and that program, that AISH program may also be key to accessing other programs and supports, right? They get health benefits because you're on AISH. Now suddenly their drugs are not covered, right? So it's very important, not that it's, some would argue it should be more money in this regard, but it's a subsistence living, a little over $20,000 a year. So it's hard, especially in a larger center like Calgary or Edmonton or Red Deer, to be able to afford. It doesn't go far. There should be more, arguably. But with that being said, you don't want to lose those supports. So making sure you plan properly. Oftentimes people say you need a Henson trust, which is a short form or an abbreviated way of referencing the planning opportunity. It came out of a case in Ontario that involved the Henson family, but basically stands for the proposition that if you have a lifetime trust with absolute discretion, making it government support friendly, we call those trusts. Another way to call it would be like an AISH trust, a trust that is appropriate for maintaining eligibility to the government supports that are there. Yeah, so that's, you want to see that. Looking at it from an estate administration perspective, if you go, hey, wait a minute, this person has a disability, they are eligible for AISH, but the will says just a gift, and that's going to put the person offside of AISH. There is an opportunity under these regulations to fix that and to create a trust. It wouldn't be a testamentary trust, but we can try to fix it after the fact. The better thing would be to do the planning, but certainly having an eye to the appropriate trust structures in place and making sure that's managed properly. And we're dealing with this person appropriately as part of the estate administration would be appropriate. So hopefully adequate provision has been made. I guess the final point, feels like I've been talking a lot here, and then you can jump in with your questions. But a big issue here on the planning side is making adequate provision.
Yeah.
So hopefully it's done well at the front end. If not, there's definitely an issue for the executor of the estate, because they have to go and figure out, how do I distribute to somebody who may need more? They would have the opportunity within 6 months of the grant of probate to be able to advance a claim in the estate. We call that family maintenance and support. So under the Wills and Succession Act, you can make a claim, or somebody on behalf of this person can make a claim. It could be a trustee, a guardian. Sometimes the Office of the Public Trustee, if there's somebody involved, would advance a claim, or a limited trustee. It can come from a number of different sources, but it would all be consistent with saying the parent, let's use the parent-child example, the parent did not leave enough money for the child, and they need more than what was allocated. So really on the planning side, it comes down to how much is enough, and working through that calculation to say the parents have this much to give away, the child has this by way of needs, how much of what they have is needed for that child to make adequate provision. And hopefully, I think most parents start with, I want to treat my kids the same. If there's one child and that child has special needs, it's easy. You leave 100% to the kid. There's no analysis, right? You've given everything you have. You hope it's enough. If there's two or more children and it's an allocation, the question becomes equal or unequal. And sometimes you have, depending on the size of the estate, you might have to make an unequal distribution, maybe like a 60-40 split between two children, or there's three children instead of a third, it's something like 50-25-25, assuming the other children are able-bodied. So it's really appropriate to do the planning correctly, because otherwise, let's be frank, you're handing over a mess to the executors, and there's litigation, and people in my profession start making too much money because we got to go to court and we've got to get a judge to fix it up. And then if there's contention or problems, how's that all going to get resolved, right, in that situation? So I think for all those reasons, really good to do a planning. If you have a child with special needs, let me conclude my little soliloquy here with, if you have a child with special needs, this is not basic estate planning. This is advanced estate planning. There's unique considerations, and it's not a do-it-yourself, get the will kit from the registry office or download something from the internet. You're bound to have a problem. You really need to work with your lawyer, with financial help, as a financial advisor, and really make sure that kid is adequately provided for, because that minimizes litigation risk. You got a good plan, and you're not handing the mess over to the executor to sort out afterwards.
Thank you, Gord. That was a lovely speech. But I will focus on a couple of things that you mentioned, more from the estate administration perspective. One, if you're an executor managing an estate with a beneficiary with special needs, you have to be careful to do distributions after probate. You have to wait at least 6 months, as you mentioned, before you do any distributions to be sure that there'll be no further claims to the estate. I think that's an important thing to highlight. And then the second, if you're managing a trust on behalf of a beneficiary, to ensure that you're not providing too much support to the beneficiary that they lose out on their AISH benefits and other governmental supports. And I know you mentioned the $100,000 threshold, but I also know that there's some assets that are exempt. And so as an executor, you could consider purchasing those exempt assets on behalf of the beneficiary so that they are not negatively impacted from what they're receiving. So can you maybe highlight a few of those exempt assets for our listeners?
Sure. The one will be their principal residence. So let's say they live in a condo, they can live independently. They're not in a group home setting, but they need accommodation. You could purchase the home. If it's where they live, it's their principal residence, it's their home. The value of that home is not included towards the $100,000 calculation. The other one is a financial vehicle called a registered disability savings plan, kind of like an RRSP for a disabled person. In Canada, we have this RDSP, registered disability savings plan, that is a unique program with unique rules that allows a parent to provide some supports and put money in place for the disabled beneficiary, for their loved one, in this specialized saving vehicle that goes into it, and everything that comes out of it is exempt for AISH purposes. So for this in Alberta, the government support program, some of the provinces and territories have slight variations on the rules, so check with your local jurisdictions. A lot of them do exempt, but I know some exempt the asset, like the actual amount in the RDSP, but then they regard money coming out as income, which could affect the recipient of the government support programs. It's not universal across Canada. Every province has made their own rules. For the most part, RDSPs, I think, are treated as exempt assets. It's their pension plan. It's their long-term savings plan. It's not really their money. It's money they're going to live off of. But the RDSP is a huge one. A motor vehicle or a specialized wheelchair accessible vehicle would be one. A prepaid funeral is another exempt asset. But the big ones are certainly your home and your RDSP, and the trust fund tend to be where the bulk of the wealth may be in terms of what is exempt.
Mm-hmm. And focusing on the home and living accommodations, I know that's another concern that many families have is, after mom and dad are gone, where is my child going to live? If they can no longer live, or if they can't live on their own, what do you tell families? What are the options out there? What should they explore prior to them passing away to ensure that their child is living in a supportive and caring environment?
Yeah, it's an important consideration, because usually, although not universally, usually where the child may reside, where the guardians live. Not always, right? The guardian really is the person who's going to decide where the child lives. It could be with them. If you think of a minor child and you're listed as a guardian, then okay, they come into your home because they can't live independently. If the disabled person is an adult, there would be a need to have a guardian potentially a guardian and trustee appointed by the courts. And so that person would decide, where is this person going to live? But the important point out of the question you raise, which is a germane one, is what if the child moves, right? What if this person you set up a trust lived in Alberta with parents gone, and now they go to live with a sibling or another provider in British Columbia? Now the rules in British Columbia are totally different. They don't have AISH, they have their version of AISH. The rules are very different. And so you've got to be careful with regard to that. So the highlight would be you want to maximize the supports that are in place for the disabled person, but recognize mobility can upset that, can change what is available. And so whoever is making the decisions about where this person is going to live has to be mindful that if they change jurisdictions, the supports that are in place will no longer be in place. Right. One of the rules for all these programs is this is helping people in this province, Albertans, and if we're looking at the context of the AISH program. In fact, there's rules about how long you can be out of province. If it's more than 30 days, you need permission. And then at some point, you may cease to be a resident. They're not interested in somebody applying in Alberta and then moving to Saskatchewan or Ontario or Nova Scotia and receiving checks from the province of Alberta when they're not living here. This makes sense, right? This is for people who call Alberta home. So, it becomes important from a planning perspective to think about, where would the kid live? And that could be the place where the decision maker is, the guardian, or it could be like they would go into their home, or are they going to move into a group home? Do they need a separate condo? So the housing is a huge issue and is one that weighs on a lot of parents with children with special needs as to what is the plan and who's in charge of making that plan, who's going to implement that plan rather, and then provide some guidance with that within the will and also within the court orders that are in place for guardianship.
Yeah, and I think you bring up a good point too, is if the beneficiary does have their own capacity to execute their own estate planning documents, then they can choose a guardian if they lose capacity or unable to make their own decisions. But if they don't have the ability to execute their own estate planning documents, then the court order would need to be done to appoint those individuals. Now, I'd be remiss if I didn't highlight you and your firm and what your lovely wife Annie does to help beneficiaries with special needs, not only from the estate planning perspective, but other supports that are available for those beneficiaries. Can you provide a little bit of an overview of that program and what you do for families?
Sure. One of the things, so this is a division of the firm we call Disability Advocates, and a lot of her work is to do that advocacy to get these programs in place. For adult children, as I mentioned, there's always having appropriate guardians and trustees in place, assuming the person doesn't have capacity to make their own decisions. So it really depends. It's just not every single child with long-term disability. Some have sufficient cognitive ability that they could be their own decision maker, but oftentimes having the right people as a backup for mom and dad and having that in a court order so somebody can start right away is important, is part of what she does in helping. And as a firm, we help people in those situations. We talked about the AISH program. The other thing is, for some people, they may be eligible for a program called Persons with Developmental Disabilities, or PDD. Now, there's very specific rules about that. That has to be, the disability has to have been in place at age 18. And there's an IQ test, has to be below 70 in order to qualify for this program. So it just illustrates that every program has its own unique qualification that you have to go through, but that could be a support to bring respite workers or other people in a support setting, or to provide funding to a group home or something like that. It's not money going directly to the child, but allows them to hire people to help in that situation. Typically, we're looking at the adult time frame from 18 till death. It doesn't stop at 65 like AISH does. That is a different time frame. The other thing really that becomes important is making sure they're eligible for the disability tax credit. So we would help people get in place with that, and that can start at birth or it can before somebody passes away. If they're a minor, there's a program called FSCD, which is a funding program for those under age 18. So we would check to say, okay, for a minor child, if that's part of the planning process, is there some eligibility for that? And then, is it appropriate to set up the RDSP? Remember, we talked about that before as an exempt asset. That could be an extra savings program that would supplement what a parent sets aside in a Henson-style trust to provide that financial security for that person. So from that perspective, that you've got a certain period of time to put money into an RDSP, and that can be available for financial support when they get, after they turn 59, they can start accessing that. So as you see, each program has different timeframes. They support in different timeframes and they kick in at different timeframes.
Mhm.
So part of our job is to walk families through that and just make sure they're getting all the programs and the support that they need, and the appropriate legal structures are in place to ensure that in a difficult situation of the loss of a parent, that we're in a scenario where the right people are in place and the right supports are in place and helping with that. The other thing that, if you're looking at it from an estate administration perspective, if you're going, hey, I'm wrapping up the estate, we're going to set up this trust, but sensing that maybe this person doesn't have everything that they need, or maybe they're eligible for more, not a bad idea to come in and say, sit down with somebody like my wife, Annie, who understands all these different government support programs, and say, can you do an audit? And we've had that from time to time. We've been hired by trust companies to say, can you go through that and just make sure this kid is getting everything that they need? So outside of the core responsibilities of administering the estate, wrapping it up, and contributing money to a trust, the estate could ensure the funds are available, or that comes out of the trust to ensure are they getting all the government supports they're eligible for with regard to that. But yeah, the key takeaways would be, do the planning to make sure you don't put the kid offside. Eligible programs like AISH, make sure are they eligible for the disability tax credit? Apply for that, because that's a bit of a gateway qualification to a whole bunch of other federal programs and different tax benefits that would be associated with having that in place. So that would be important. And then looking at contributing or setting up that RDSP and starting to put money into that for that, in addition to what they're going to leave by way of this Henson Trust. So you can see that you kind of have to look at the totality of that whole picture to make sure that you can see, is the person adequately provided for? And more importantly, from a parent's perspective, do they have the peace of mind to know their kid's going to be okay? Because what they fear, of course, is that if they're gone, the kid's not going to be okay. There's going to be risk there, or they're not going to have the quality of life that they want. So really, it comes down to providing that peace of mind to the parent to make sure the right structures are in place so the child will be okay.
Just listening to you, I realized this is probably one of our longest podcasts, but I think it's important. You've highlighted a lot of important information here, and it just goes to show how complex this can be and how experts are needed to properly plan and administer estates with this level of complexity. Thank you for sharing your wisdom with us, Gordon. I hope our listeners benefited from this. Please reach out to him if you are dealing with a scenario in your own family. I highly recommend his services and his wife's. A little bit of a plug for you.
Appreciate that, Jenna, but I'm not going to let you off the hook that easily, only to say, at the risk of extending the length of this podcast, to say that I think you do valuable work in terms of searching out appropriate trustees and executors for doing this type of work. I think on the planning side, we've sent people your way to be able to say, hey, the choice of who is the executor, who is the trustee is a complex one. We have some choices there. Let's think through the right alternative and get a cost-effective solution, but the right solution to deal with this family situation. So I think the work you do on guiding people on the choice, I think a lot of times you probably run across and get hired by people who have a child in the family or children with special needs, because that's a unique consideration. And we need somebody that's going to be there for the long term, right? Mm-hmm. This trust could be around for the rest of this kid's life. If they live decades into the future, we may need a trust company. And that's a whole level of complexity that I know you guide people through. There's an element of, in that situation, I would also advocate to our listeners saying, consider a guardian estate company to help you make good choices on that, or to review your existing choices.
Thanks, Gordon. I love how we just promote each other. We're both the best, aren't we?
A mutual admiration society. But I guess in all seriousness, I like what you said. There is an element of complexity here, and you need help working through it, especially in a situation where you haven't updated your will in some time. Your situation evolves, it changes, the rules change, tax laws change, the needs of your child may change in terms of what they can and can't do and how they can support themselves. So that all has to be looked at. And if it hasn't been for a while, it's good to refresh and take a look at that. We're happy to help people through that. Thank you for this topic and an opportunity to do some teaching on it.
Absolutely. Thank you, everyone, for coming today and listening to us learn and educate. And we look forward to hearing from you next time. Please feel free to subscribe. You listen to podcasts and check out our lovely faces on YouTube. We are smiling and we're happy to be here. Thanks so much.
Take care.